In various petitions filed under section 156(3) of the Cr.P.C, the magistrates are giving directions to the police to conduct a preliminary inquiry before registering an FIR. Now, what this leads to is that the police, under the guise of conducting a preliminary inquiry, they never register an FIR. So it goes on and on and on forever, and then the party is forced to approach the High Court under section 482 of Cr.P.C and get a direction for the police to register an FIR. So why cause this unwanted delay by giving a direction to the police to conduct a preliminary inquiry before registration of FIR? Now, before proceeding into how I feel this can be resolved, we have to understand the judgment of the Supreme Court in the Lalita Kumari versus Government of UP case. For those who don't know, the Lalita Kumari case is a constitution bench judgment from the Supreme Court that is reported in 2014 to ACC 1. Here, in the concluding paragraph, certain guidelines were given in regard of registration of FIR, and if a cognizable offence is disclosed in the information given by the informant, then the police has to register an FIR. In case they want to conduct a preliminary inquiry, then a specific category of cases have been given where the police may conduct a preliminary inquiry. So the first thing is that this list is an illustrative list. The second point to be noted here is that even in these 5 category of cases, the police may conduct a preliminary inquiry before registration of FIR. So it's not mandatory to conduct even in these 5 cases. So it all depends on the facts and circumstances of each case, which will determine whether a preliminary inquiry is needed or not. So in all other cases, registration of FIR in cognizable offences is mandatory for the police before they proceed into investigating the same. So what if a person approaches the magistrate and the information discloses a cognizable offence? So he will be directing the police to register an FIR and investigate. What if the material is not sufficient to entitle the magistrate to give such a direction? Then in such a case, one can say that the magistrate can ask for more material from the petitioner, that is the informant. In certain cases, the material can never give the magistrate a complete picture whether a cognizable offence is disclosed or not. In such cases, will it be fair on the informant that the magistrate directs the police to conduct a preliminary inquiry and then register an FIR if a cognizable offence is made out? No, because the informant already has approached the magistrate because the police do not respond to his information. So in such a case, will it be right for the magistrate to tell the police, okay, you take care of this preliminary inquiry and you try to ascertain if a cognizable offence is disclosed? That will not be correct, and it only gives the police more time to not register an FIR and just delay the registration of an FIR. So it also forces the informant to approach the High Court, and it causes unnecessary delay. The next thing is it causes unnecessary expenses for the informant. In such a scenario where the magistrate is not able to arrive at a proper finding and he needs more material, it will be fair if the magistrate is able to give an interim direction to the police to go out there, go to the field, conduct a preliminary inquiry and come back with a report. And based on the report, if a cognizable offence is disclosed, the magistrate may direct the police to register an FIR and proceed with the investigation. Now here it is very essential to note that the report of the police is not binding on the magistrate, obviously. So even if the police say that no cognizable offence is disclosed in the interim report, even then the magistrate may direct a registration of FIR. And even if the police say there is cognizable offence disclosed, the magistrate may decide otherwise. So the magistrate is independent from what the police concludes in the inquiry report. But the power to give an interim direction in 156(3) petitions must be noted here, because in case you are an informant and you are approaching the magistrate and he wants to give the police final direction to conduct a preliminary inquiry, then you can put forth this prayer to the magistrate and say, no, I want an interim direction so that the police don't delay registration of FIR. Let them go out there, let them conduct the preliminary inquiry within the time frame that is given by the Lalita Kumari judgment. Let them submit the preliminary inquiry report to the magistrate, that is you, and you please decide after seeing the interim report whether there is a cognizable offence disclosed or not. And I think this will help the informant side counsel or the informant, if he is appearing as a party in person, to ensure that you get a proper result from your 156.3 petition. If you see, the possibility of these interim directions to call for a preliminary inquiry report or a status report from the police in 156.3 cases was seen in cases like Shri Subkaran Luharuka vs State, which is reported in 2010 ACC Online Delhi 2324. Paradise Credit Private Limited vs State of NCT of Delhi, which is case number being criminal MC 2936 of 2012, which was decided by the Delhi High Court on 20/12/2013. Syed Hussain vs State, which is reported in 2022 ACC Online Delhi 2428. Now in all these cases you can see that interim directions were given to the police to file a status report, and based on the status report the magistrate arrived at a final finding, which obviously can be different from what the police has concluded. So it is always better that the magistrate is able to decide from a preliminary inquiry report that is filed by the police, rather than giving a final order to the police to conduct a preliminary inquiry and register an FIR if a cognizable offence is disclosed, which, as I discussed earlier, will cause a lot of mischief, and the police will never register an FIR in such cases, because from a lot of bundles I have read in the past, I know that the police will indefinitely quote Lalita Kumari, and they will quote it very wrongly. They will say that they are entitled to conduct a preliminary inquiry, and so they'll be conducting it for n number of months and sometimes even years. So that is in direct conflict with the Lalita Kumari judgment itself, which says that a preliminary inquiry must be conducted within a period of 7 days. So I hope this information was useful to you, and do use this in your 156.3 petitions and ensure that the magistrate gives an interim direction and not a final direction to the police to conduct a preliminary inquiry. Do share this with your legal community if you found this video useful, and do subscribe to Lawyer Society for more of these interesting legal discussions. Thank you. Until next time.